All right, let's talk about a concept that's really shaking things up across all kinds of industries, from crypto to finance. It's called regulation by enforcement. Now, this is a pretty controversial way for the government to make policy. Instead of writing rules for the future, it works by punishing actions that have already happened. It's a really powerful tool, and you can bet it's sparking a massive debate.
Okay, so picture this. You're playing a big game, but the referee only tells you what the rules are after you've already made your move. And how do they tell you? Usually by blowing the whistle and slapping you with a penalty. That's pretty much the spot that businesses and innovators find themselves in here. I mean, how are you supposed to comply with the rules if the lines are only drawn after you've supposedly crossed them?
So, to really get why a regulator would even want to be that kind of ref, we first have to understand the two main tools they have in their toolbox for setting the rules of the game in the first place.
And the difference is, well, it's night and day. On one hand, you've got formal rulemaking. That's all about the future. It sets the rules for everybody going forward. It's a public process, but man, is it slow and deliberate. Then, on the other hand, you have enforcement. It's basically the exact opposite. It looks backwards. It's retrospective. It penalizes one specific company for something they already did, usually through a super fast-paced investigation or a lawsuit.
So, you gotta ask, why would any agency pick this more, confrontational path? Why choose enforcement over just making the rules clear for everyone? Well, if you look at it from the regulator's side, there are actually some pretty compelling reasons.
It really boils down to three big things. First up, speed. In markets that are changing at lightning speed, like crypto or AI, the old, slow rulemaking process just can't keep up. Enforcement lets regulators jump in right now. Second, it's a way to experiment. An agency can try out a new legal idea on one company and see what happens before they lock it into a permanent rule for the entire industry. And third, well, it can just be more efficient. It lets them skip the incredibly costly and time-consuming process of formal rulemaking.
And believe it or not, this whole approach isn't some new thing. The legal foundation for it was laid down way back in 1947. It was a huge Supreme Court case, SEC v. Chenery Corp. And the court's decision was simple, but it was profound. It said that it's basically up to the agency itself to decide whether it wants to make policy through these big, broad rules or through individual lawsuits. That one decision gave agencies a ton of flexibility.
And the effect of that ruling, it's been absolutely massive. For more than 75 years now, Chenery has given regulators the green light to build out the law piece by piece, one lawsuit at a time. It's a process that actually looks a lot like how common law develops, where the rules of the road emerge from individual court decisions over decades.
Okay, but as you can probably guess, not everyone's a fan of this approach. It's drawing some really fierce criticism from people who argue it creates a system that's just unpredictable and, at its core, totally unfair.
And this criticism isn't just coming from companies getting sued. Listen to this quote. It's from Hester Pierce, and she's a sitting commissioner at the SEC, the very agency that's often right in the middle of this whole fight. She's basically saying that instead of writing clear rules for new markets like crypto, the agency is just suing its way to a policy, creating what she calls a cobbled-together framework.
So let's break down the main arguments from the critics, because they're pretty strong. They say it's just not fair to businesses. It creates all this uncertainty that ends up stifling innovation, because who wants to invest millions if you're afraid of breaking some rule that hasn't even been written yet? But beyond that, it also dodges some really key parts of our democratic process. It completely bypasses the public notice and comment period, so experts and everyday citizens don't get a say. And it lets agencies skip the hard work of a real cost-benefit analysis, which can lead to some pretty sloppy, uninformed policy.
And look, this isn't just some abstract legal theory. We've got a real-world example right here. For years, there was a standard way that investment fees were structured. In 2010, the SEC actually tried to pass a formal rule to change it, but they couldn't get it done. So what happened? They pivoted. They issued some informal guidance, and then they just started bringing enforcement actions against firms, effectively creating a new rule by punishing people without ever actually passing one.
So this whole back and forth has been simmering for years, right? Well, now it's reached a full-on boiling point. We're seeing major legal challenges go all the way to the Supreme Court, and they could potentially unravel decades of agency power as we know it.
For about 40 years, the thing that held up all this agency power was a legal idea called Chevron deference. It was established back in 1984, and the idea was pretty simple. If Congress passes a law and parts of it are a little vague, the courts should defer to the expert agency's reasonable interpretation of that law. This gave agencies a huge amount of power to fill in the blanks.
But as you can see here, the days of Chevron being the king of the castle, they're pretty much over.
It was established in '84, sure, but by the 2010s, it was getting hit with heavy criticism. And get this, for the last 6 years, since 2018, the Supreme Court hasn't used it once. Not once. So the very foundation of all that agency power is seriously cracking.
And as Chevron fades, something new is rising to take its place: the major questions doctrine. This is a new principle that basically says, hey, for the really big stuff, the issues with vast economic and political significance, an agency can't just find a loophole in some old law. No, it needs clear, direct, explicit permission from Congress to act.
So what's the bottom line here? The whole relationship between the courts and federal agencies is changing, big time. That old era of just automatically trusting the agency's judgment is over. Now, judges are actively stepping in and asking whether these agencies are overstepping their authority, no matter how they try to do it.
So what does all this legal wrangling mean in the real world? Well, this isn't just some abstract fight for lawyers to worry about. The outcome of this has massive, massive stakes for businesses, for consumers, and really for the entire economy.
What we're looking at is a brand new set of trade-offs for, well, pretty much everyone. For businesses, less regulation by enforcement could mean more certainty, which is great. But it also means you're waiting a lot longer for clear rules in new industries. For consumers, you might get clearer rules in the long run, but you lose that quick, agile protection from new problems that pop up. And for the regulators, they lose that flexibility to act fast in a crisis, which means they have to rely on a much slower Congress to get anything done.
And all of this brings us to the huge, central question for our economy today. In a world where tech and markets are moving faster than we can even comprehend, how do we find the right balance? How do we protect people from real emerging harms quickly, while also giving everyone the fair, predictable rules of the road that innovation really needs to thrive? There is no easy answer, that's for sure.